you all for joining us for today's podcast. We appreciate you being here. My name is Fraser Cobb. I'm the Executive Director of the Florida Orthopedic Society and Bone Society of Florida. We appreciate you tuning into today's content because this is going to be a follow-up on the last program we released at the start of July that focused on the bills that were taking effect. This bill we're going to discuss today is actually has a little bit more of an impact on our members. So we wanted to specifically highlight that in a special session of this podcast series, just to highlight that a little bit more specifically and make sure our members pay a little bit more attention to this bill due to the potential impact. As we get started here, I do want to thank again our partners in this podcasting series, Danna-Gracey and the Florida Orthopedic Risk Purchasing Group. They do provide us the technology and the encouragement to record these programs on a routine basis. So with their partnership, without their partnership, this would not be possible. So we appreciate their assistance as we roll out this information to our members. And I'm really pleased again to introduce today's guest, Tony Large. Tony was the star of the show during our last podcast, and because she did so well, we decided to invite her back for this next session. We're going to talk today about legislation, which was House Bill 241, which passed, which deals with Parental Bill of Rights. And as we dive into the specifics, I first want Tony to set the stage for us a little bit on the history of how this bill came to be debated this year, and a little bit about the advocates behind that. Before I have her chime in on that, though, I would be remiss if I did not again introduce Tony officially. Tony Large is the lobbyist that has represented the Florida Orthopedic Society for a number of years now. She has her own firm, Large Strategies, up in Tallahassee, and does a great job representing our patients as well as our physician members. So, Tony, thanks for joining us again today. And as I teed up, let's start with the history around House Bill 241 and what got us to the start of session where this legislation was filed, and then some of the debate, throughout session from the advocates.
Yes, and it's very unique. And thank you, Fraser, for the introduction. It's my pleasure to be here today and also to represent the Florida Orthopedic Society. I will say House Bill 241 is a huge bill. And ironically, the part that's affecting orthopedic surgeons is only about 2 pages. So a 2-page section of a 40-page bill is really what's causing concern. The bill was signed into law by the governor, so it now is in effect. I will say we'll need to come back next session and try to fix the glitch that's in the legislation. The bill really, though, was centered around the school system and a parent's rights with their child in the public school system and or charter or private schools. So it set out a parent's bill of rights of what a parent is able to do or not do, or what information they're able to access or not have access to, or even if they're able to object to their child receiving certain information as part of their educational experience. Ironically, though, every good intention sometimes is followed with an unintended consequence, and that unintended consequence is at the tail end of the bill. It talks about healthcare providers, and previously we did have a requirement for written consent before care is provided to a minor. And I think all of us support parental involvement in the care the care that we provide to their children. In fact, it's helpful, right? The parent's the one usually bringing the child to the appointment. The parent's usually the one also making sure that child follows up with any care plan that's given at the appointment. The problem being, though, is that point of injury care. Orthopedic surgeons know it way too well, and many cases orthopedic surgeons are the volunteer team physician on the sidelines of high school athletic events. Everyone comes to that game thinking it's going to be a successful game, and they're walk away as the winners of the game. But many times in the game, a player does get hurt, and thankfully orthopedic surgeons there to rush in and offer that point of injury kind of care. So what the legislation says is, except as otherwise provided by law, and I'll go through what the exemptions are, a healthcare practitioner. So just to let you know, this isn't just physicians, but it's any healthcare practitioner who is licensed under 456.001. So that's actually any healthcare provider that has a board under the Department of Health. So all of those healthcare practitioners, whether it's yourself, your PA, your ARMP, it even goes as far as respiratory therapists and the other types of practitioners regulated by the Department of Health. So any of those healthcare practitioners they cannot provide or solicit or arrange to provide healthcare services or prescribe medical drugs to a minor without first obtaining written parental consent. And as we discussed, that written parental consent is, easy to do, say, in a doctor's office setting, but where it's hard is point of injury care. I mentioned volunteer team physicians on the sidelines of high school athletic events, but there's also that situation where you're, as a physician, at a playground with your own child, and the call, you hear the nanny screaming, "Help, help," my child's fallen off the monkey bars, and you run over and you see that there needs to be immediate care given to that child. And y'all step in, right? You're there to help stabilize that patient, give the first aid and urgent care that's needed. Sometimes, an ambulance is called, but you're there to make sure that that child gets the care they need until that ambulance arrives, or also until, a decision can be made. Does this child need to be driven to the hospital by that nanny? Or that mother? I use the babysitter nanny scenario simply because of the fact many times kids are in a scenario where they're there with a caregiver and they can't always, you wouldn't always even have a parent there to give that written parental consent. And just like the pelvic exam bill that we have discussed in previous podcasts, written consent is quite difficult. We laugh and say, do physicians now need to have in their back pocket a consent form that they can hand to a parent to say, hey, I know your child needs this urgent care right here at, point of injury, but actually I can't do that for you unless you sign this consent. We all know that's impractical. And so we'll have to look at ways in which we can minimize the impact, at least for the time being, until next session, where we can hopefully come back and educate the legislature even more about that. Really, in many cases, volunteer point of injury care, whether the child's being pulled from the swimming pool and needs, CPR, the child's fallen off the monkey bars, or even a child that's just been stung by a bee and all of a sudden has an allergic reaction, that you jump into, do what you've been trained to do, and that is provide care, in many cases, life-saving care to patients and even children. The irony is, if the child's 18, then guess what? You don't need the written consent. If the child's 17, you do. So we also feel like this kind of creates a bifurcated system in which a physician's always having to ask, well, wait, is this a minor? And thus, am I facing, which now is a criminal misdemeanor if you provide care without that written consent. The two exemptions that were in the bill, I actually should say three. One is if you're providing care pursuant to 743.064. And what that is emergency medical care to a minor in a hospital emergency department. So ironically, you might be, an on-call specialist and you get the exemption in the emergency department when you're providing care, but you don't get that same exception when you see an auto crash on the side of the road and you stop and provide that care. The other two exceptions that are in law are for EMS and paramedics in their if they're providing professional services, i.e. if they're off duty and provide them, no, it doesn't cover them. But if they're responding via the ambulance, it does. And the other one is actually in a college health services facility. So those are the three: emergency care provided in a hospital emergency department, EMS, and college or university healthcare services. I do get the question a lot, doesn't the Good Samaritan Act cover me? The Good Samaritan Act is really about liability protection. It has nothing to do with written consent. So this piece of legislation now that is law would still say, even though you'll get liability protection in this corner, you still have to have written consent in this corner if responding to care to a minor. So it definitely will need your help, all of you listening during the summer, to educate legislators on the need for point of injury care. We call it acute care in many cases, and that how it's completely unplanned, but there's not a physician out there who hasn't jumped into action when the call for help has occurred, especially for your minors.
Yeah, and Tony, that was one of the issues, the acute care exemption that we tried to get into the legislation as it moved through the process. Ultimately, we weren't successful as the Senate took the House version that did not have that acute care exemption. But that's really created the basis of our call to the governor to veto that legislation. Unfortunately, he did not follow follow our request and sign the bill into law, because again, it was a much larger piece of legislation that had its own set of advocates and supporters behind it. But I think that's the key issue for us moving forward is the where the, I guess, the limitations of the Good Samaritan Act versus the responsibility of a physician to have written consent, and how we deal with those acute injuries that may happen where a parent is not available. So I think, does that create the kind of framework or marching orders for us as an organization of what we need to fix with this legislation to make it palatable for our members?
Yes, and ironically, the Senate, leading up to its vote on the Senate floor, had agreed with us when the bill was heard in education. And I must say, that's what made this bill so unique. Most of the time, bills that deal with healthcare go through healthcare committees. Since this was 80% an education bill and only 20% healthcare, it really went through all the education committees and pretty absent any of the healthcare committees. But in that hearing at the Senate Education Committee, the sponsor of the bill, Senator Ray Rodriguez, placed an amendment on it, our request, that would have exempted both acute medical conditions and care provided pursuant to 768.135. So the 768.135 Florida statutes is a reference to the Volunteer Team Physician Act, where you do have liability protections currently, and we wanted to make sure that that type of care was exempt, and as well as the acute medical conditions, so the point of injury care. So the Senate did agree, the amendment went on. It actually stayed on for 2 more committee hearings. It wasn't until more of a procedural issue that caused a problem, in which the Senate bill was slower to get to the Senate floor. The House bill had already been heard and was over waiting for the Senate to vote on it, and they just picked up the House bill and didn't amend it to move forward. I will say probably some of the forces behind that is more of a conservative legislature, a legislature with that's young, with young children. And there's this worry about children going to get things like birth control or contraceptives, and that the parent doesn't know about it. So in reality, their intentions were, I want to make sure written consent is there before, say, Planned Parenthood prescribes birth control pills. But in reality, what it also did was include any care that's even acute care, injury, point of injury care is also now falls into that category of requiring written consent.
And I think that history is important too, because clearly this bill was not an attempt to address unwarranted sports medicine that's being provided to kids out there. It really is an attempt to rein in some of that healthcare that may not be supported by some parents, as you mentioned. So I think that's important for us to realize as a community, is this bill was not targeting us primarily. We just are dealing with the unintended consequences. And again, I think that gives us a little bit of a platform for us to make targeted changes to the bill moving forward that won't run afray of those advocates that really want good parental rights in the statutes, but also would support timely care, quality care being rendered to their injured child, right?
Totally agree. And that will be part of the education this summer as we move forward in asking for a glitch bill to make sure physicians aren't discouraged from providing care. Particularly, it's ironic, I think, written consent's not required for bystander providing care or first aid to that minor. But now you would get to where the physician has a different standard when they provide that kind of volunteer first aid to stabilize either a player on the field and or just someone that they rush over to give medical care to.
And so I think in the interim, as we deal with the ramifications, there's a few things we can work on, right, which we've already talked about. Again, this is a criminal statute now, because it is a misdemeanor for you to render care without written consent. So, we can engage those that have enforcement over criminal acts and determine, the extent of what they are going to pursue as far as physicians rendering care in the community with or without written consent of a parent for a minor. The other issue surrounds, participation forms and what truly does written consent constitute, if you will. Can a parent sign a consent form for pre-participation in a school event, in a club event, and how long will that consent last? And we had a lot of that debate in the pelvic exam consent law as well. One thing we should mention, the Florida High School Athletic Association is moving forward with updating their pre-participation forms as well to specifically reference the statute. And Tony, I know we're still looking at those changes and discussing this with our legal counsel as well to determine how far that consent extends. But again, in that situation, it's just a sanctioned Florida High School Athletic Association event that pre-participation form potentially is on file with the school. To talk a little bit about our concerns around those participation forms and the limiting factor with the FHSAA as well.
Yeah, and one of the things I said to the Florida legislature when they were considering this is, we love the Florida High School Athletic Association. We work hand in hand with them. Orthopedic surgeons have taken on volunteer team physician positions, in schools across the state, and it's integral to making sure that student athletes get that point of injury care they need, whether practice, football camps, or at the game. And though I would say the Florida High School Athletic Association plays a big role in kids playing sports, we have seen as well that the club sports that are out there. So now athletes are playing year-round sports. Half of that might be at the school on that team. The other half is outside of the Florida High School Athletic Association and in these club sports. So even if we make revisions to the authorization form that parents sign at the beginning of a season, our biggest concern was, in many cases, the volunteer team physician that's on the sidelines. Though I'll give you the example of where my children go to high school, Leon High School. They're providing those volunteer team physician services at that game, not only to the home team, so Leon High, but in many cases, the traveling team, they don't travel with a physician. So what that means is that volunteer team physician is providing the care for the home team and the visiting team. It might be easier for us to assure with the coach prior to a game that all of those players on the field their parents have submitted that signed form, the written consent. But it's really tough for a physician to have that reassurance that this visiting team also has all of their forms filled in. It is also kind of unique because, the legislation says that you may not provide services unless you have first obtained the written consent, parental consent. So some of the legal questions we're looking at is a blanket exemption form that says, say, Leon High School or Leon County School District is able to provide, first aid care or any kind of acute care that's needed while that player is playing on behalf of that school. Will that give that physician enough coverage that they need to be assured that they're not going to get hit with some of these, with this criminal penalty? For example, it probably isn't going to list specifically the physician's name. It's probably going to be more of a blanket consent form. Part of the education with legislators too is that this is a voluntary basis in which many of our orthopedic surgeons provide care at these different sporting events. So many times a practice will come together at the beginning of a week and say, here are the different games that we would like to have a physician at to, provide this volunteer care. Who's available this week? And, so it changes. So that's another issue as well too, to making sure that as you give that really important, critical volunteer care, that you're not inadvertently putting yourself in a position where there could be some criminal penalties or at least a misdemeanor charge if you didn't have that written consent. The hope is no one would ever ding a physician for providing care that's really, crucial to these student athletes. And why I say crucial is last year there was legislation that talked about heat strokes and about how there needed to be wet baths or cold baths at practice areas for athletes because there were several deaths in our state from heat strokes. So we've done so many things, and especially the Florida Orthopedic Society took the lead as well on concussion protocol and the need to make sure that it's the medical specialist there on the sidelines making the call and not the coach that might have had an invested interest to quickly move that injured patient back or injured player back to the playing field. So, a lot of it's education, the realization of what really is happening on the football field, the soccer field, the lacrosse field. there's many avenues in which physicians are really providing needed community care and making sure that those physicians are safeguarded.
And I think that's one of the concerns about our sports medicine community too. In addition to the Orthopedic Society, there's organizations like FASMed that have invested a lot of time and energy to move athlete safety forward. As you mentioned, that don't want to see some of this rolled back as we just deal with a paperwork issue around consent, right? So I think that's a lot of their concern. And paperwork's important. Our partners at the risk purchasing group would tell us that documentation is critical in all instances. So for your team doc, how do you truly put that consent form in your medical record to prove that that consent was received if the school district is collecting it several months before in the office? So there's a lot of lingering questions. You did mention the expanded role of clubs for student, not student athletes, but young athletes, and certainly for our docs that participate in club activities. Hopefully those organizers are having these conversations like the FHSAA is around pre-participation forms. But I think that's a critically important question for our team docs to be asking now before they volunteer and cover a club event is, has the organizers taken that step of collecting consent from everybody? And, let's face it, we have a lot of traveling club teams that come from other states too, and they don't have similar legislation in effect. So I think it's paramount that our team docs understand that and start asking those questions before they, agree to cover and provide care in those instances.
Yeah, and I was talking to some of our hospital partners as well and realized there's a lot of like sporting events, whether it's little mini marathon or triathlon or different things that are sponsored by not only our orthopedic practices, but sometimes our hospitals in the area. And part of that sponsorship is they have the volunteer physicians there in case there's any injuries. So I think we're going to see it not only in the sports gaming side of things, but also in different events that's designed to promote, healthcare activity, healthcare sporting. And, many times it's brand new folks running their first little, marathon or, half marathon. And so it's very important that we have those physicians there. So we'll do everything we can moving forward to make sure that we can impact this legislation as it's implemented, but also start looking for sponsors for next year to, fix kind of what we think is an unintended consequence in this bill.
Yeah, I guess that's how we'll close today. Our final, talking point is again making sure that you are having conversations with those that you're working with to cover their events, that they understand this law is in effect, and then start to work with us on identifying your concerns and what you see in the field, which help us tell a story on why this is so problematic. The legislature does come back into session early next year, right, in January. So committee meetings will be starting probably late September?
Early September, actually. We'll be back early September. And here's another thing we all need to remember about the upcoming legislative session is the census data that was collected. This is the year Florida has to do reapportionment and redistricting. So most legislators are going to be really focused on what does my Senate and House seat look like that I'm going to have to run for reelection in. So that's going to dominate most of the session. So these very important glitch issues, we really have to redirect their attention and say, no, we need you to focus because we need this addressed this year because we are afraid it's impacting the care that minors are able to get right now.
Perfect. So that's your take-home message. We need your help telling a story. So as you see issues with this bill being implemented and what impacts it has on you at a practice level, please send that information to Tony, myself, so we can turn that into, talking points, stories, and ways to illustrate our concerns with this legislation to our elected officials. So with that, Tony, thanks again for another fantastic job. We will definitely have you on speed dial to bring you back to do another of our podcasting sessions with us. Again, thanks to our partners at Danna-Gracey and the Florida Orthopedic Risk Purchasing Group for giving us this platform to engage our members, and hope you all have enjoyed today's program.